you. You know, usually when they put a lawyer last on a panel, the audience thinks I'm going to dump on everybody else and say everything you heard is wrong, which is not what I'm up here for. I'm going to talk very, very briefly about regulatory liability and then shift mainly to product liability. As Greg pointed out, NHTSA is supposed to make an announcement later this year on whether to proceed to regulate connected vehicles. But the most important point at this point is none of the emerging technologies you see on cars today, lane change avoidance, forward collision avoidance, are ones where there's any federal standards at all. The only driver assist technology that has a federal standard in place is electronic stability control, the anti-rollover technology has been on all new cars for several years now. So, you know, with respect to product liability, I've been working with connected vehicle issues since 2005. And as a lawyer, the question I get far more than any other is, when connected vehicles collide, or when automated vehicles collide, who's going to be liable? And, you know, there's a lot of misperceptions out there that are driven by those types of questions. And so what I want to focus on today is sort of what's the reality, what's the perception and misperception? Are we really talking about new and different legal issues, or are we talking about the same landscape where we analyze other types of failures and accidents? And what guidance can we learn from other transportation sectors that have warning and crash avoidance systems, aviation, transit, railroads? And this is an important point that I'll return to later on. There are various theories of product liability, and I'm not going to go over those, but it's important to remember that whatever the theory is in the case, the plaintiffs still ultimately have to prove causation. They have to prove that the failure in the system actually caused the accident or injury. And the courts deal with two types of failures, what we call the pure information failures, and that's where the GPS tells you to take a left, and there's no left-hand turn, so you ignore it. Maybe in another situation, the GPS tells you to take a left. There is a left-hand turn, but it's a one-way, and you're going the wrong way, and you don't realize it. So the courts struggle with that issue a little bit as to whether pure information is a product. But again, we can look to other transportation sectors, and we see that collisions based on navigational errors based on information are quite common in aviation, for example. But most of the failures we're talking about are traditional types of failures where a system simply breaks down, and the courts in those situations will just apply a normal traditional product liability analysis. Now, this last bullet point here I want to talk a little bit about because it's an emerging area of some concern to defense lawyers, and that is the non-product liability cases, and these are typically class action cases, where the plaintiffs say that the product was not accurately advertised and represented. If it had been accurately advertised and represented, the plaintiffs wouldn't have bought it, or they wouldn't have paid as much for it. Therefore, they're entitled to diminished loss. There are two cases right now pending against an OEM based on exactly this type of claim, that the telematics device did not perform as the OEM advertised it to perform. And we see these types of claims in many other types of industries, consumer products, food, sporting goods, not just automotive. But it is a concern because these cases are class actions, so even though an individual's so-called loss might be fairly small, when it's aggregated in a class action, you can have potential liability in millions or even hundreds of millions of dollars. Now, we have a great deal of experience we can learn from existing technologies, automotive technologies. There are thousands of cases on the books on failure to install technologies or misinstallation. We're going to have ever-increasing experience base with these new technologies, driver-assisted technologies like lane change and forward collision. So we'll see more and more how the courts handle these cases. And I want to get back to the point I made in the second slide about what guidance can we learn from other transportation sectors, because despite all the hype about accident scenarios and liability scenarios with connected vehicles or automated vehicles, it's very different to come up with an accident scenario involving motor vehicles that hasn't already happened in other transportation sectors. Many of you here are too young to remember this wonderful movie from the 70s, but this statement is one of the most famous quotes in American movie history. And I use it here because I see articles about a future of an accident-free driving environment. But let's face it, we live in a real world, and things fail, and sometimes communication systems fail, and sometimes when those failures occur, the results can be unfortunate or even catastrophic. This is a communication failure. This was an accident in the Washington Metropolitan Red Line in June of 2009 where a trailing train failed to detect the presence of a stopped train, and the operator of the trailing train was unable to manually stop her train in time. She was one of the 9 people who were killed in this accident. And you can see just from the figures here, the 9 fatalities, 52 hospitalized, 12 million in damages. The system still, after 4 years, has not been fully re-automated. I don't cite this as an example of something that I would expect to happen with connected vehicles and automated vehicles. I cite it because it is an example of failures that conceivably do happen. But when they do happen, as catastrophic as this was, the courts worked through it using the very same types of product liability analysis that they use in typical motor vehicle accidents that happen every day. I want to talk just for a moment about automated vehicles because that's the big buzzword in the regulatory community and in the OEM community. First of all, autonomous vehicles, self-driving vehicles, it's not a revolution we're seeing, it's an evolution, because we've had automated technologies for years. ESC is an automated driver assist technology. The technologies you see on cars today and that you will see coming down the road in the next few years, the lane change avoidance, the imminent crash braking, and so forth, those are all different levels of self-driving driver assist technologies. The liability issues may differ with respect to vehicles that are either fully automated or nearly fully automated, depending on the driver role and other factors. But again, the framework for liability analysis is going to remain the same. And I don't mean to suggest that there won't be some complicated issues. I mean, one, for example, that others have cited is, let's say you're driving down a rural road, your car is equipped with the latest technology, but an older car coming the other way isn't. That car goes over the center lane towards your car. And this, by the way, as you probably know, is a very common fatality scenario in the U.S. Now, if you're a driver and you have control of the car, you have to make a decision. Do you turn into the vehicle coming towards you? Do you stop? Do you go off the road? Well, let's say your vehicle is fully automated and you're basically passive in that situation, and the computers and the sensors make the decision. What does the computer tell the vehicle to do? Let's say the computer directs the vehicle to swerve off the road to avoid the incoming car, which is a logical, rational choice. But let's say as a result, the car slides down a ditch, hits a tree, and the driver is killed. Could someone argue that the computer made the wrong decision, that a responsible driver in that same situation would have made a better decision? That's a tough question, but the courts will work through those questions, and so it's not going to be an impediment to these technologies going forward. And I say that because I read articles again and again where it says these liability issues have to be resolved before the technologies can move forward. Well, that's not the case. These technologies are moving forward. So just some questions from a product liability standpoint for aftermarket suppliers. If you're thinking of developing a device or an app for connected vehicles or automated vehicles, well, what's the technology you're talking about? Is it a safety technology? If so, is it warnings only? Is it crash avoidance? If it's a non-safety technology, does it have an impact on driver distraction, which is something which both the courts and government are very concerned about these days? Does your device modify or deviate from factory spec? And we have clients coming to us from time to time say, well, I've got this device, I plug it into an OBD port, and it can make the vehicle do things that it doesn't do based on the factory specs. And they say, we want you to do an analysis of that. Well, typically in that situation, where you are creating a situation that goes beyond the factory specs, you typically want to do a heightened product liability risk assessment to protect yourself as much as possible. What information are you providing to users? With safety-related information, warnings, instructions. If there's any safety implication in your device, it's just as important to tell the user what the system or device can't do as it is to tell the user what the device can do. Obviously, what liability protections do you have in place with respect to your suppliers through indemnification or other arrangements? And obviously product liability insurance. The one other point I raised earlier that's not on this slide, if you're making a performance claim for a device, make sure the performance claim is substantiated. Make sure you have empirical evidence, engineering evidence, testing evidence, whatever, that can substantiate that claim so that if you do get hit with one of these deceptive advertising economic loss cases, you have the support for the claim that you made. Thank you.